opening the thing. Right, so good morning folks, thank you for coming here today, and I want to talk to you all about the right to be informed, which is one of the 8 rights that individuals have under the GDPR. So what is this right to be informed thing that I talk about? Well, I refer to Article 13 of the GDPR, so that's a whole load of legalese. If you want to get it in English, basically what we're talking about, the right to be informed, is where at the point of capture, where you're getting somebody's personal data, you're going to have to tell them everything you're going to do with their data. And be open and honest, completely open and honest and transparent about what you're doing with their data. This comes from the transparency principle of the GDPR, that you're going to be, as I say, completely open and honest. And it's at the point of capture, so if you're capturing somebody's personal data on a website, and you have a form that, your name, address, etc., you're going to put maybe a link up there to say, if you want to find out what we're doing with your personal data, click here, and it'll take you off to another web page that's going to give them all sorts of information about what you're doing with their personal data. That's on a website. If you were capturing the data on a form, a paper form, you would have on that form, somewhere on the form saying, if you want to find out what we're doing with your personal data, please visit our website here, and this is the page you go to. Or maybe if they can't access the internet, or they don't have any access, or they're not allowed to access the internet, you would have it on hand, printed out, that is available. So if they ask, you say, here you go, this is what we will do with your personal data. But you must make the information about what you're doing with your personal data available to them at all times. So basically, what must you tell them? You must tell them everything. And you must be completely, I say, open and honest. Tell them the truth. So, specifically, what we need to tell them, you want to tell them who and where you are. What's your company name or your business name, where your address is, contact details, maybe the name of a representative in the company that they can contact. If you have a company that requires a data protection officer, you also must give their specific contact details as well, but that's only if you have a data protection officer, which is a very specific role within the GDPR. A lot of small companies probably won't need one. You must then also tell them what is the purpose of you capturing their personal data. What are you going to use it for? Why are you capturing it? And also, what is the legal basis for you capturing the data? Now, there's 6 legal bases for getting people's personal data. Like you might have a legal obligation, so your employers would have required to capture your name, address, telephone number, date of birth, PPS number, etc. for revenue purposes. They have that as a legal obligation. You might have it for contractual, for performance of a contract. So with the like with an insurance contract, people need to sign up for insurance, so they have to give their personal data to execute the contract. You'd also have a consent. We all know all about consent. We all had all those emails. If you're processing data based on consent, that's another legal basis. There's also then there's the vital interest of the data subject, which is literally having pieces of personal data to save their life. There's public interest, which is really only applicable to public authorities and Garda Síochána. That would be for particularly around CCTV monitoring of a wide area. And finally, there's legitimate interest. And legitimate interest is kind of a very, it's a very wide-ranging one, but it's very, the GDPR has put a lot of control over it, that you need to be very, very specific about legitimate interest and carry out an assessment on whether you need to, or whether you're allowed to use legitimate interest to process somebody's personal data. We'll talk about that at a later date, because that's a whole different area. And if you do have to base it on legitimate interest, you have to then specify, tell the individuals what is the legitimate interest that you have for processing their personal data. You must also tell them who you are sharing the data with. You have to list out all of the companies or other individuals that you might be sharing your data with. If they're too numerous to list all in one go, if they're a specific category of a company that you want to share data with, you can just specify the category. And then there is, if you're transferring the data to a third country that would be outside of the EEA, you would need to tell them what country it is going to, and if there's what's called an adequacy decision between the EU and that country. Now, an adequacy decision is basically a legal agreement between the EU and those other countries to say that they're going to give the protection of personal data under the GDPR in that country. And there's a very, very limited amount of countries that have an adequacy decision presently. It's growing all the time, but there's only currently about 12 countries with adequacy decisions in place. And it's not just countries. If you're giving data to an international organisation, and they might end up being, transferring that data around the globe. Again, you have to check with them and see if they are going to give you the same kind of levels of guarantees. So if you're going to use something like a Google Drive or Dropbox, they potentially are saving data, transferring data to other countries, and you've got to make sure that there is adequacy protection for personal data that you share with those companies. But you must tell the individuals about these organisations that you share data with. So that's not really so bad. There's only a few items there, but there's more. We have things like how long are you going to hold on to the data? So if you've got a retention period, you must declare what the retention period is, or what is the criteria for determining that retention period. You have to give them a list of their rights. Now, the individuals have rights. Right to be informed is one we're talking about here, is one of them. They also have the right to get access to their data, right to update their data if they find it is inaccurate, a right to erase data in very limited circumstances. They have a right to get their data in a portable format. They have a right to object to processing, basically where you're processing data based on consent, they can object to that and remove their consent. They have a right to restrict processing, and finally they have a right in regards to automated decision making and profiling. And we'll cover these other topics at a later date in more detail, but you just have to list them on this right to be informed so that they are aware that they have these rights. And then you must tell them how they can lodge a complaint. If you do something, if the individual concerned thinks that you've done something wrong with their personal data, you have to tell them how they can lodge a complaint with the Data Protection Commission, giving them the information they're required to do that. If you do carry out any automated decision making or profiling on people's personal data, you must tell them, where applicable, you must tell them what logic is used to process their personal data, and also then any consequences of that processing, like if there is potentially a legal outcome or some kind of a negative effect on them for this automated processing, you must tell them what those potential consequences are as well. And then if the data is going to be used for a statutory purpose or for execution of a contract, you must, I'd call that out on there and say, this is what we're doing with the personal data, and if there's any kind of an obligation for them to actually provide the data, if they're required to absolutely provide you with some data, you have to tell them if they don't give you that data, what are the consequences of not providing the data. And then finally, if you want to change in the future what you're going to use the personal data that you've captured with them for, you have to go back and, if you're going to use it for a different purpose, you have to go back and tell them, again, give them a new set of right to be informed about the new purpose that you're going to use their data for, and get their consent, or you may not need to get their consent, but you just need to tell them about the new purpose. So, that's not so bad really, is it? But not quite there yet. What we've talked about there was where we got personal data directly from the individual. And now bring you Article 14 of the GDPR, which is, again, qualified legalese, so putting it back into English, where you receive the data indirectly from the individual. What do you need to do? Again, you need to tell them a lot of stuff. So it's not where they're giving you the data themselves directly, where maybe the data is being referred to you. Somebody's giving you the data separately, or you've got it, a business card from a conference, or you've looked up their name, address and telephone number, email address on their website, the information that's in the public domain. So where you're getting the information indirectly, you will also now need to provide them with a whole heap of information. So, that looks all fairly familiar. This is all the stuff we had on the first slide last time. So, it's all the same. And, look, we have all this as well, but, okay, they're all the same as well, except for the last point there. That is, obviously if they're signing up for contractual or statutory purposes, they're giving you the data directly. There's no chance that they're going to be giving you it. You're not going to get that data indirectly, so that doesn't really apply there. So what does replace this one though is you must provide, tell them where you got it, how you came across their data, where you got it from. Was it in a public site or something, so that they are aware of how you came across their information. So you must tell them that. And again, if you want to use the data for a different purpose in the future, you must also provide them with the new right to be informed. So, in specific respect of the indirect data, you must provide them with that because again, you're getting the information indirectly, so they don't have immediately have a link that they can click on to see what you're going to do with the personal data. So you must provide them with a copy of the right to be informed, or give them access to the right to be informed within a reasonable period of time, but at least within 1 month of you getting their data. Or if you use the data to communicate with the individuals, you can provide them with the right to be informed information at the time of the first communication. And but if you're going to share the information with other recipients, other companies, you must at least inform the individuals about it at the time you're sharing that data, so they're aware of that their data is now being shared with these other recipients. So that's it. So we now have any questions?